Thank you very much. Thank you to all for being here, and thank you for the Case Matrix Network for inviting me to this very important event and to show what our members in El Salvador are currently doing with this draft bill on cooperation. The Rome Statute process in El Salvador has been very particular. Since the several challenges that were presented for the ratification of the statute to the challenges that now are currently the parliamentarians facing for the implementation, to the political alliances that were necessary to cast this very close vote in the parliament for the ratification last November. My organization, Parliamentarians for Global Action, that is a network of more than 1,400 parliamentarians around the world, working on justice, democracy, peace, and security, has been working in El Salvador since 2002. We have been engaging with members of parliament for the ratification, one goal that was achieved last year, and now for implementation. On this regard, El Salvador, the Rome Statute process in El Salvador is very particular because both bills, the bill for ratification of the amended Rome Statute and the bill for implementation of the Rome Statute, were presented by the government to the parliament together, showing how important is for the government the implementation of the statute. This is very different from the processes in other countries in the region. For example, Argentina and Uruguay, that have very extensive and detailed implementing legislations, have had a different process. First, it was the ratification, and then the government started to draft this cooperation legislation. In Chile, we have the implementation of the crimes first, the ratification then, and now the government is working on the cooperation legislation. In El Salvador was both bills at the same time, showing how important it is for the government to fulfill the obligations as a state party. Because of all the challenges that were presented for the ratification, most of them, as explained, Olympia, in other countries also have happened constitutional challenges, the parliament decided to treat first the ratification and then to move forward the implementation. Immediately after ratification, which happened in November last year, the parliamentarians, a lot of them members of PGA, specifically the president of the Foreign Affairs Committee, Diputada Karina Sosa, understood the importance of the cooperation of states with the ICC. They understood that in those cases where the ICC has jurisdiction, the state must provide the necessary national mechanism to enforce its orders. They also understood that the cooperation of the state is necessary to ensure the integrity of the ICC proceedings. And they understood that any delay on the cooperation in the country would entail a delay on the proceedings of the court, and probably most cost for the states funding the ICC process. I'm going to briefly mention some of the parts of this cooperation draft bill. They include most of the articles of Part 9 and Part 10, enforcement of sentences, of the Rome Statute. This is very interesting. They include elements of confidentiality of the request for cooperation. They also include ample rights of the accused during the fulfillment of the request for cooperation, following Article 55 and 67 of the Rome Statute. They also include detailed procedures on how to move the request for cooperation in the country, which are the authorities. They divide the cooperation for arrest and surrender from the other ways of cooperation. They have also concurrent request for cooperation, simplified surrender. So many of the elements that we normally see in Part 9. However, I would like to focus on these two articles first that are in some way odd to be included in this bill. The first one is Article 3, that refers to the non-retroactivity of the ICC jurisdiction. For all of us that are working on bills that implement Part 9 of the Rome Statute, it's very strange to find an article that refers to the non-retroactivity. But this may origin from one of the main obstacles for ratification, that is not only that has not only been faced by El Salvador, but for many other countries at the moment of ratification, and this is the misinterpretation that the court could have jurisdiction for crimes of the past. As we know, El Salvador have a very recent history of a civil war. Many of the persons that have been participating in this conflict are now in the presidency, in the government, in the parliament. There is an amnesty law in place in El Salvador. Therefore, there was a big fear of the court being able to investigate and prosecute those past crimes. That's why we can understand why this Article 3 is included in this implementation bill. The second article that I want to refer to is Article 14 of this draft bill that refers to sentencing. The article says something like the sentence or the penalty that is going to be applied for Rome Statute crimes cannot be greater than that sentence that is included in the national legislation. In the way that is phrased, it could be read as it is imposing into the ICC judges to take into consideration El Salvador legislation when they are deciding on the sentencing, which of course cannot be the case. This article may have its origin from another challenge for ratification that was an unconstitutionality challenge, because El Salvador Constitution prohibits life imprisonment, while, as we all know, the Rome Statute allows it. So this was the main challenge, and we can see how this article ended up being in this legislation. Now, PGA, as a network of parliamentarians, not only provides the international and political support to our members, but we also provide the technical assistance. We organize expert seminars, we provide legal memos, we also provide commentaries to criminal codes, and regarding cooperation, we have a reference law on cooperation for Latin American countries that gathers the best practices for different legislations around the world on cooperation. And based on this legislation, we have proposed to our members to work on improvement of this bill. Regarding this article, we have suggested to be moved to Section 4 of the bill, that is a section that implements Part 10 of the statute, enforcement of sentences, and rephrase the article by saying that they will accept those persons that have been sentenced to a sentence that is applicable or that is allowed by their national system to fulfill the sentence in the territory. This is that they will not accept anyone that have had a sentence of life imprisonment. This is in line with several of the agreements or the declarations that a lot of states have done when they have deposited the instrument for ratification, and would allow to have El Salvador the exercise of their jurisdiction over those people that are serving the sentence in their country. I would like to now move to three main elements in which are interesting that are included already in the Bill of Cooperation that we're also working with our members to improve the language. The first one is voluntary cooperation. The second one is the focal points and the channels of communication. And third one is related to freezing of assets. I hope that the time will allow me. So regarding voluntary cooperation, as I just mentioned, there is a special part that is Part 4 of the bill that refers to enforcement of sentence. It's very interesting that includes a whole procedure on how to enforce the sentence in the territory. Very interesting that includes as a focal point the territorial judge that is in charge of enforcement of sentence and the penitentiary system, which helps not to have any delay in the communications between the court and this judge for enforcement. Also, it says that no national court will be able to modify the sentences, and the only thing that we can see room for improvement is that only nationals could serve sentence in the territory of El Salvador. Of course, each state have the sovereign decision to take this stand and say only nationals that have been sentenced by the ICC are going to serve their sentence in our territory. However, if we take into consideration that Article 86 of the statute entails a full cooperation of the state. The ICC has no territory, has no prisons. We could see how this restriction could not be completely in line with this idea of full cooperation with the ICC. Moreover, in the recent enforcement agreements framework, enforcement of sentence agreements that have been signed with the ICC, this restriction is not included. And also we explain to our members, because we're trying to expand this article, Article 47 of the legislation, that the government can decide on a case-by-case basis if to receive this person for the enforcement of sentences. That means that it's not that all the people that the court would like to send to El Salvador is going to necessarily be accepted or will be serving their sentences there, but the government can decide. The other main element of voluntary cooperation that is already included in the bill is the protection of victims and witnesses. This is very interesting because it makes a reference to the Rome Statute protected measures in Article 68, and also it refers to this special law that is in El Salvador for the protection of victims and witnesses. It's a very broad law, and it really helps to provide all the right measures for the protection of the victims that are in danger because of their relationship with the ICC. However, and the reference in these articles does not specifically say anything about a restriction on nationality. That is very interesting. But it doesn't explicitly say the other way either. So we would like to work with our members to reinforce the idea that El Salvador will accept other victims and witnesses from different countries. So we'll accept the relocation of those victims and witnesses that are in danger. And two of the other elements that we are trying to work with our members is to include support of victim participation in the ICC proceedings and a national fund for victims of international crimes. Then we have other two voluntary ways of cooperation, interim release and final release. Those two ways are not included in the bill at the moment, but our members are interested in including the text. Then we have a very important point for us, that is the focal points and the channels of communications. As you all know, the Rome Statute does not provide any specific authority to be in charge of cooperation or to be the liaison with the court. That is why many of the states use the same system that they have for mutual judicial cooperation with other states. But this system of cooperation is very different. With the state is horizontal cooperation, while the cooperation with the ICC have elements of verticality and elements of horizontality. So the same authority may not be the most appropriate for the cooperation with the ICC. In our reference law, we consider that a dual approach or a dual focal point approach could be more effective, having not only the Ministry of Foreign Affairs, but also the Attorney General or the Supreme Court being direct focal points for those requests for cooperation that entail judicial or prosecutorial measures. We consider that in this way, the law on cooperation will facilitate a full and prompt cooperation for state parties with the ICC, which is essential, as it was mentioned before, to ensure the court will fulfill its mandate. Any delays on responding to the cooperation request reduce the court's efficiency, and it might eventually lead to losing a unique opportunity. We have seen that in the situation in South Africa, as it was mentioned, where we lose the opportunity to have the arrest and surrender of al-Bashir. But when the judiciary was involved, they actually have said that he should have been arrested and surrendered to the court. So we see how there is a different approach from the Ministry of Foreign Affairs in certain cases and the judiciary. We also consider this approach is not unique. It's not that we are coming with this idea by ourselves. It has been already used by several countries. We see that Czech Republic, Estonia, Lithuania, DRC, Gambia, France, in the case of urgency, have declared when they were depositing the instrument of ratification that they were going to use a dual system of communication with the court. El Salvador is very interesting because they have a communication from the ICC to the Supreme Court, which is fantastic. However, all the communications always have to go through the Ministry of Foreign Affairs, which is understandable, of course. And with this approach, we're not saying that the Ministry of Foreign Affairs should not be involved. This is quite the contrary. We consider that all the communications have to also be done through the Ministry of Foreign Affairs, and the Ministry of Foreign Affairs have a very important role that is of supervising, overseeing, and supporting the prompt implementation of this cooperation request. Moreover, the Ministry of Foreign Affairs should be the one in charge of all those cooperation requests that entails administrative measures, for example, issuing visas, granting the transfer of a person. So all those requests that nationally do not require a prosecutorial or a judicial measure to be taken in the territory should go only to the Ministry of Foreign Affairs. However, the other ones, when there is the necessity for a court to act or the Attorney General to act, needs to also go directly to them to avoid any problem in the or any delay and to make more efficient the communication. I have very little time, and I just think that the sui generis, I just want to mention that the sui generis nature of the ICC may allow us to give this different way of cooperation with the court, not only through the Ministry of Foreign Affairs, and also to grant the independence of the judiciary in a very positive way, to have court with Supreme Court and OTP with Attorney General. So I don't think I have much time to go through the identifying, tracing, and freezing of assets. I will just only say that it's included in the legislation. We are trying to work with our members to generate proactive and proper motu actions from the financial investigators nationally to then communicate with the court. We're also working with our members to set urgent procedures, not only for freezing of assets, but also for arrest and surrender. And all of these processes are being analyzed by the legal advisors and by the parliamentarians themselves. Just to finalize, I just want to summarize a little bit what the draft bill on cooperation in El Salvador has. It implements most of the articles of Part 9 and Part 10. We're working on these three very important issues on cooperation: mandatory cooperation, voluntary cooperation. And I think that it was mentioned by Olympia that there is a different way of implementing for monist and dual systems. But we think that even those countries that have a monist system, it's very important that they have an implementing legislation to allow and to really set which is the national mechanism, which are the authorities that are going to be in charge of really implementing this request for cooperation when they arrive from the court, and they can do it in a very efficient way. Of course, at Parliamentarians for Global Action, we consider that parliamentarians have a main role to play here. They are the ones drafting very comprehensive cooperation legislation, and we are, of course, very happy to support them. Thank you very much for your attention.